On the 4th of July, Americans love to celebrate with parades, with bands playing snappy martial music and huge firework displays. What we celebrate is the country's original independence and the continuing commitment to the human and political freedoms for which the United States has become a beacon throughout the world. Good morning. Welcome to Newsmakers. On this July 4th weekend, freedom from England is a distant historical concept at this point, but American freedoms, especially those enshrined in the Constitution's Bill of Rights, are a living reality in every American's daily life. Over the last few weeks, we have been reminded of that by a rash of Supreme Court decisions that have once again made an effort to clarify the meaning of such fundamental concepts as religious freedom in a pluralistic society, of free speech in the age of the cyberspace, of the right to bear arms in an age of rampant violence. In addition, the court struggled with issues like physician-assisted suicide, where it isn't clear whether or not rights exist in a constitutional sense or simply privileges that can be either extended or withdrawn at the will of a legislature. In the shadow of our annual celebration of America's freedoms, we devote this morning's Newsmakers to the recent Supreme Court decisions. To review the court's decisions and evaluate their significance, I'm joined this morning by two local law professors. Ronna Greff Schneider teaches constitutional law at the University of Cincinnati College of Law. John Valuari also teaches constitutional law at Chase Law School at Northern Kentucky University. Welcome to Newsmakers.
Good morning. Thank you.
Just one quick thing. Why did we get this rash of decisions right at the end of June? Is there something that caused the court to burst forth here?
Everybody clears their deck just before vacation. The annual Supreme Court term ends at the end of June. They're as anxious to get on vacation as you are, and just like most of us, they save the hardest things for the end. So the most controversial cases are usually the ones to get decided at the end of June, and the easy ones get decided earlier.
Okay, well, that sort of explains why the timing. Ronna, let's just start out. There were two cases here right towards the end that dealt with the issue of religious freedom. One dealt with a law that was passed by the United States Congress, which a lot of religious leaders really supported and favored and kind of shocked that the Supreme Court overturned it. What's going on there, and what really did that decision put in place?
Well, what you're referring to is the Religious Freedom Restoration Act. And that act was passed, actually, by Congress in response to the United States Supreme Court decision in 1990. And the reason that Congress passed that statute, and as you mentioned, with the support of a lot of religious people as well as religious groups and others, the reason that Congress passed that act was to provide what they thought were greater protections for religious freedoms than the Supreme Court had demonstrated in its constitutional interpretations. The question that was before the court this year was whether or not Congress had the right to basically interfere with that decision. That is, did Congress have the right to pass a statute that was in many ways viewed as a rebuff to the Supreme Court interpretation? Now, that was the Supreme Court's view of it, which is basically why it struck it down. That is, Congress did not have the authority to overrule a constitutional interpretation by the Supreme Court. That is solely the job of the Supreme Court. Congress...
And the only way to do that would be...
Constitutional amendment.
Constitutional amendment,
Absolutely.
Not by a law.
That's correct.
Okay.
Congress had another interpretation to that, as you might guess, and that is Congress argued it was not at all trying to overstep the Supreme Court, but instead was trying to provide statutory rights that it did not have to constitutionally provide, but chose, as you say, at its will to provide. Supreme Court rejected that argument and struck it down. Now, what that means practically for people in terms of religious freedom is that the law will go back to that 1990 Supreme Court case. Now, that may seem like a simple matter, but it's not. And proof of the difficulty in that really is the other Supreme Court decision that came down last week, also dealing with religion.
And that quickly deals with something that around here people are very familiar with, that the idea that in aid to schools, that public schools can provide teachers in certain areas, but they have to teach in these vans that we see outside of parochial schools.
That's
and
right.
the court said it's not necessary to have those vans anymore. Is that correct?
That's correct. And this case also is a little bit unusual. The facts of the case really were first litigated back in 1985. There was a United States Supreme Court case back in 1985, the same case actually, in which the Supreme Court said you could not have public employees, that is public teachers, teaching inside parochial schools. And that's why they literally have these vans parked outside, because that's considered public property even though all their students are parochial school students. There was a lot of dissatisfaction with that case because of the cost involved in having these vans. And many people over the years since 1985 argued, isn't this ridiculous that we're spending this money on vans when we could be spending it on educational services? And so this case has kind of been brewing for a long time. What makes it unusual is the fact that the way they got to the Supreme Court was not by starting another lawsuit saying this is a problem and so on, but rather saying that they think that the law as interpreted by the Supreme Court has changed since 1985, primarily because of a change in the people who serve as our justices, and as a result, they should be able to have their case reheard, the same case.
John, that is, I think, something that can be very confusing to people. I mean, here, 10 years in terms of constitutional development isn't all that long, 12 years, 1985 to 1997. And we are flipping on the stand here as to what the meaning of the Constitution. Does this bother you?
Well, it'll bother me or not, it's inevitable, especially when you start out there 9 justices on the Supreme Court. If you have a 5-4 decision, all it takes is one change or one reconsideration to turn it into a 5-4 decision the other way. And it's not surprising that we've got close and controversial decisions in the religion area, because you've got two competing but contradictory schools of thought. One school of thought in this area says that it's unconstitutional for the government to give direct aid or funding to any religious institution, that it's bad both for government and for religion to have this happen. That's why the original decision said that you couldn't fund government-paid teachers to go into parochial schools. On the other hand, another point of view says it's discriminatory to exclude a religious institution or religious people from a generally available government benefit. Now the problem is, both of these propositions sound plausible and make sense, but they contradict one another. How do you reconcile the difference? And the court hasn't figured it out. So in areas like this where there is turmoil, where there isn't a clear principle, you're going to have things going back and forth until, constitutional time is geologic. It may take a generation or two to get things sorted out, and then you'll have a clear rule.
Just a final point on that. Does this open up the possibility of the constitutionality of vouchers? Are we going to hear a lot more about vouchers for parochial school system students?
I think you have been, of course, hearing a lot about vouchers, and I think you'll continue.
But does this fuel it?
I think it does fuel it. I absolutely think it fuels it. But let me just say one thing that may be a source of comfort. While it is true that it is an area of turmoil, and that it seems that 12 years we kind of are making a change and so on and so forth, this is an inevitable part of having a constitutional system like ours, where you have people who serve for life on a court and make rulings that are the rulings for the land. This is not a new experience. We've had this for the 200 years of our history. We've also gone through this.
We'll live through it. Let's move on to something a little bit different here, and that's the area of another basic freedom, the freedom of speech as it relates to a new technology, the internet, because here we've got something that's really different. Nothing is more American than the right of free speech, but with the spread of the internet, when surfers of any age can readily access sexually oriented material from the privacy of their own homes, what right does Congress have to censor the web to protect children? Congress tried to do exactly that last year, and the law was quickly challenged and, we might say, struck down. Is that right?
Oh, sure.
And was there ever any real question about this? The First Amendment free speech has been something that the court has stood pretty solidly for over the years.
Well, the only doubt was this. Your free speech rights depend not just on your speech, but on the medium. You are freer to speak, for example, in a newspaper than you are on television or broadcasting. Because of the relative scarcity of the broadcast system and because it's considered publicly owned, the government has far greater right to regulate speech on TV or on the radio. So the question became, is the internet more like TV, where government has greater power to regulate speech, or is it more like printed medium, like a newspaper or magazine, where government has much less? And what you're talking about in this internet case is so-called offensive speech, speech that is sort of sexually related but not obscene. If you want to view it this way, speech that's not PG and not NC-17, but sort of R. Is this type of speech on the internet something that can be governmentally regulated? Offensive but not obscene speech on radio can be regulated by the government. Offensive but not obscene speech in print can't be. So essentially what the Supreme Court had to decide is the internet more like a newspaper or more like a TV set?
And it decided
more like a newspaper.
Does that surprise you? And secondly, there's a lot of popular feeling out there, especially among parents, that they're uncomfortable with the internet. Now that the Supreme Court has made this ruling, does that close the case, or are there any alternatives out there?
Well, the only part actually that there was one justice who did not buy the whole opinion dealt with exactly that kind of problem, namely whether or not there was anything in the act that could constitutionally regulate non-obscene but offensive and material that went to minors. Only one justice, joined by one other justice, was able to win that part of the case.
So this isn't a 5-4 sort of thing.
This is not. This is one of those rare times in this case, with this court, where you have a clear direction on the law. However, I think that what will happen now is that you will have the real development of other technologies that will provide parents with those tools. And I think that really was the purpose of the decision. They wanted to make it clear that this was not something where the law is going to regulate. It's going to be kind of freedom of the technology to develop. That's consistent. Actually, just today, the president has said that with regard to the internet, what they want to see happening is basically, as he put it, a Wild West development. Let it all develop by itself. That's completely contrary, by the way, to the position that the government took in the internet case, where they said they were fearful that the internet would not develop because people would be scared away by all this indecent material on the internet.
Basically what we're dealing with is a technology that people really don't know how to respond to yet, and trying to figure out whether you're governments or parents trying to figure out how to deal with this is still an open case.
Now let me add just one thing that probably a lot of your viewers will feel comfortable with, and that is that when this case was argued, many people wondered whether or not the justices who were of an age that they did not grow up with computers would really understand this new technology, and people were very pleased that they really grasped the meaning of all of this, so that there's hope for all of us who did not grow up with computers that we too might understand all this.
Okay, very quickly before we take a break here, I want to go to one other issue, and that is the Brady Bill. The Brady Bill was passed in 1993 in order to create a check and a waiting period for people who wanted to buy firearms. The Supreme Court ruled that a section of that bill was unconstitutional. They were going to disallow it, that the states had to do the checking. What's really at stake here? Is this essentially a states' rights issue, or did they really strike down the Brady Bill itself?
It's a states' rights issue. The question is, can the federal government tell the states what to do? Can they commandeer state officials, in this case local sheriffs, and tell them, we, the federal government, are going to tell you that you have to perform certain duties on gun checks and things of that nature, rather than doing it yourself? And essentially what this decision said is, because we have a federal system where both the states and the federal government are sovereign, the federal government can't go so far as to tell the states to do this. The federal government can and will do it itself, but it doesn't have the power to order the states in the interim to do it because the federal government said so.
Now, given the fact that the states have successfully, some of the states have said they will not do it, they were the ones who were suing, is your expectation that this bill will now go away, or what do you think is going to happen to this Brady Bill issue?
I don't think it's going to go away, and it's not going to go away primarily because this is an interim point until the necessary data banks are developed and so on and so forth. So I don't think this issue is going to go away by any means, and it was not. It's important to understand too that the entire bill was not, the entire act was not struck down. Only that part of it that dealt with that states' right issue.
Real briefly, the federal system is supposed to be complete within the next couple of years of background checking, but the more general issue as to what power the states had or when the states can say no to the federal government, that issue is most certainly not going to go away. Because we talk about statutes where the federal government mandates certain state acts. You're going to see more and more challenges to that.
Particularly when the federal government not only mandates it but doesn't fund it.
Okay, so this is part of that sort of unfunded mandate.
Unrelated to gun control.
Right. Okay, we're going to take a break for a moment, but at the end of its term, the Supreme Court did a lot to dispel the image as a sleepy place. We have only scratched the surface. Stay with us, and after the break, we'll try to catch up with a few more court decisions and figure out what they all mean. Over the last 5 years, the repeated actions of Dr. Jack Kevorkian to assist seriously ill people commit suicide has landed Kevorkian in court and has brought a new set of ethical and legal questions into high relief. In January, supporters and opponents of assisted suicide demonstrated while lawyers argued the issue before the High Court. Now, here is, I guess, an issue that in some ways is kind of like the internet question in the sense that it's sort of a new question on the horizon, at least for Americans, of doctor-assisted suicide. That I'm not aware that the court has made. There isn't a history of making decisions in this area. What really was decided in this particular case by the court at this time, John?
Whether or not there's a difference between doctor-assisted suicide and simply refusing life-prolonging treatment.
Okay.
Whether or not there's a difference between killing and letting die. One side said, look, the result is the same, so how you get there really doesn't make a difference. Those were the proponents of a right of assisted suicide. The other side said, traditionally the Judeo-Christian system has made a big distinction between killing and letting die. So if I have a fatal disease and I reach the point, let's say, where the chemotherapy or whatever is too painful and I just don't want any more, and I have a right to refuse treatment, and let's say the progress of my disease will eventually kill me. That's so-called passive euthanasia. The active euthanasia is where someone who is in a painful or terminal state has the aid of a doctor or other medical personnel to hasten the death, to actually bring it about. And that's essentially what the court had to rule on. Whether in earlier decision, the Cruzan case said that you had a right to refuse unwanted medical treatment. This case dealt with the further question as to whether or not you had a right to a doctor-assisted suicide, to medical aid in dying.
And what was the court's decision here?
Well, the court's decision was that you do not have a constitutional right to physician-assisted suicide. And that's an important point to make because this case did not decide whether or not a state legislature could pass a law that provided for physician-assisted suicide. It simply said that the Constitution does not give an individual a right to that.
In other words, you can't demand it if you live in a state that says that it's illegal to do that.
That's correct, and that was exactly what was at issue in two different states here, Washington State and New York State. Each had laws banning assisted suicide. It did not answer the reverse question.
So again here, this revolves around a states' rights issue. The court is saying the state, this is in the purview of the state. Is that
well,
correct?
It's more an individual rights issue in the sense that the Constitution sets a floor for individual rights. If you have a constitutional right, that means the state can't restrict it. But if the state or the locality wants to give you more rights than the Constitution requires, that's fine. That doesn't violate your rights to get more than you're entitled to.
Now, is there a parallel on one level and a contradiction on another level in terms of how this court dealt with this particular medical issue versus how a court back in 1973, the Supreme Court, dealt with Roe versus Wade, where in effect, I guess my impression is that the Supreme Court at that point could have left the abortion question in the hands of the states, at least for a period of time, and sort of let different states handle it different ways. But they moved in and said, no, here is sort of the basic structure. Whereas this court said, we're going to leave it out there for the states. We may revisit this in the future. So is this sort of, did the Supreme Court learn something from the way that the abortion question developed?
Well, I would hope so, but they've set up a problem, because basically they've answered this question in the exact opposite way they answered the abortion question. Because the root question in both problems is the same one that was the title of a movie and play: whose life is it anyway? If you say that the life or your body belongs solely and exclusively to you, then you have the right to do with it what you want, be it either abortion or right to die. If you say that your body doesn't, or your life isn't wholly your own, that the state or society has some interest in it, then you can regulate that. And the problem that the Supreme Court's going to have to deal with down the road is when they decided the abortion cases, they assumed that the individual did have paramount interest in their own life and body. Whereas in the assisted suicide case, they rejected that same argument. Now, eventually, sooner or later, they're going to have to put these two bodies of law together, and they're going to have to make a choice as to whether or not they accept the proposition that your life or your body is wholly and exclusively your own.
So what I'm hearing is that we could either hear more along this doctor-assisted suicide and move towards ratifying that as a right, seeing that as a right, or we could reconsider abortion and move more in the direction that and away from the 1973 decision. Is that what we're hearing?
Well, that's a possibility, but I'm not sure I totally agree here. And that is, I don't think that the two issues necessarily have to go together. They may, but they don't necessarily have to. And the reason that they don't is because in the abortion area, while it's true you're dealing with who can control the life, but you're also dealing with the issue of when life, what people consider to be life. You, of course, don't have that issue when you're talking about physician-assisted suicide. So in many ways, it's much more analogous to the abortion in the very late stages of pregnancy than it is to where we have the big controversy usually going on, and that is abortion in the early stages of pregnancy. So I don't think the two issues necessarily have to come together.
Okay, we only have about 2 minutes left. Let me very quickly. Is there a pattern here that you see in these cases that we've discussed? Is there a theme that this court is on?
Well, real briefly, its own supremacy and the rights of the state certainly seem to be two patterns that are detectable.
And is that fit into a generally conservative court?
A conservative, but also a conservative in a libertarian sense.
In a libertarian sense, okay. Right.
I see a trend going on in the First Amendment area. That is, I think the court is very, very protective over speech rights and will continue to be that, almost to the exclusion of any other rights. On the other hand, with regard to religion, which is also under the First Amendment, I think it is proceeding along the grounds of dismantling a wall separating religion and the state.
It's dismantling,
it's dismantling it.
That
still
particular
exists,
one.
But it clearly is not as high as it once was, and there's at least a big door, if not a crumbling to the wall, separating the two, between religion and the state.
Those things are in the same amendment.
Same amendment,
and
very different approaches by the same court.
Very quickly, do you agree with that analysis?
Yes.
So that there's these two different things going on with the First Amendment. This is complicated stuff. You are very clear. I appreciate that. And when the court makes other decisions in the future, I hope you can come back and visit us again.
Be glad to.
Thank you. Thank you for being with us this morning. Join us again next Sunday morning for another 12 Newsmakers.